Um,
Anna
okay.
started recording.
Now we have this sort of mix-up with accounts. I don't know what's happening, but different names or the same names.
We have the same person, yes.
Yeah. Traveling together, so it kind of merges. So yeah, okay, an official welcome from our side to the new Belgrade Legal Theory Group meeting, although a smaller one, but due to the circumstances, more than enough. And I'm happy to welcome our today's presenter, Elena Marchese, who is a postdoc researcher in philosophy of law at the Bocconi University. Today she will talk about truth and knowledge in asylum decisions, which, as I can see, is part of her wider research interests that focus in general on theories of truth and evidence, judicial epistemology, and legal argumentation, also understandable coming from the theoretical context that she grew up in. So without further ado, you have 30 minutes for the lecture, and then we can proceed to discussion for about 30 minutes also. Thank you.
Thank you. Thank you to all. I will now try to share my slide if I reach. Mhm. Just a second. Okay. Just don't know why I can't find the window, but
Usually you have to like open the PowerPoint presentation and then press share. And then it will appear. Yeah, perfect. We see it.
Okay. So, okay. As you know, I will talk about truth and knowledge in asylum decision, and I starting to focus on this topic because I realized that evidence scholars didn't give a lot of attention to this field. That is a quite actually a quite interesting one because it has some peculiarities that the criminal or civil context doesn't have. So I starting to study this, and I want to share with you some like knowledge on this topic. So among the aims of this presentation, there is the tentative to enlarge, as I said now, the discussion about international protection to epistemic fields, because very often this topic is restricted only to political debate, and in my opinion, this is not a good thing for the quality of decisions. Then I will try to defend a specific epistemic approach and to give to you some insights, very small ones, on truth. Then, as I said, I will try to encourage evidence scholars to study this context. So my presentation is divided in two parts. The first part will be on knowledge, and in this part I will treat what I call an integrated epistemic approach, and I will show you a case. Well, actually, a very little part of a case, but maybe in the discussion part we can like go deeper in it. And in the last part, I will talk about truth. So, two epistemic approaches. Why I choose to start with this? Well, because when I started studying this field, I realized that there is a huge division, a great opposition between two approaches. The one held by institutional literature and the one held by academic literature. This means basically two different conceptions of knowledge. Institutional literature, indeed, think about knowledge in the sense of justified true belief. So in a classical way. Academic literature, instead, the ones that treat asylum in particular, think about knowledge in sense of construction of a situated point of view. In this case, in particular, the point of view of the applicant. I will not go deep into this, but I will only say to you that these two approaches have different characteristics in terms of ontological assumption, the method, the knowledge method, the results that they achieve, and the aim that move the approach. From the one side, we have traditional epistemology, the one that came from Locke, Hume, and so on, the scientific knowledge that has the aim of finding truth or certainty or objectivity in general, while the critical epistemology has usually the aim to reach the subversion of a dynamic of oppression. And this, in particular in this field, means to change the oppression reality of the applicants, that the applicants live. My thesis on this is that these two approaches are individually insufficient for a good evaluation of these cases, so the asylum cases, and that they are not incompatible as the majority of the scholars, institutional one and academic one, believe. They are insufficient for itself because the traditional epistemology is a disembodied knowledge, and it does not give importance to the subjective part of the proof that in this field is very important. We know indeed that in the asylum field, we have to prove the risk, and we have to prove the objective part of the risk and the subjective part of the risk. So the traditional epistemology lacks in particular tools for doing a better evaluation of the subjective part of the risk. Critical epistemology instead seems to be unable to provide practical tools to operators like fact finders and policy makers. I'm thinking about, for example, the epistemic injustice approach. If you look at these works in general, not not all, but in general, they do a lot of theoretical work, but they lack to provide practical tools for operators. So they find some problem, but they don't give tools to change things in practical. In this opposition for me is very negative for this field because it entails disorientation of sector operators. It feeds the view that see the international protection as only a political problem, and this entails a lack of protection at the end. And I think that it's good to think the international protection as a political field, and the political debate is a good thing. But what I maintain is that if we root the political debate in better bases, such as good reasons, epistemic reasons, we will have a better political debate. So I will try to do this. And how will I try to do this? I will try to talk about this integrated epistemic approach that basically try to put together the tools of both the approaches. Why? Because the disagreements between these two approaches, in my opinion, especially about shared goals in protection, are often gradual and can be resolved. The implementation of this integrated approach requires a systematic cooperation. It's not a simply problem of interdisciplinarity of tools used. I think we need a more systematic and complex way of treat the asylum cases. We need, I think, ex ante tools and ex post tools. Oops. Among the ex-ante tools, we have the training of operators to improve the quality of working conditions, to avoid biases, to promote the trust bonds between stakeholders in these proceedings, and also, most important, to assure legal assistance from these people from the early stages of the proceedings. As ex post tools, I suggest that we need a systematic monitoring of decisions in order to check the quality of reasoning and justification. And this kind of idea is also developed by Federico Piccinelli with reference to the criminal field, in reference also to epistemic injustice, to avoid epistemic injustice. So I think it's something very important, because if a decision maker knows that someone will check his reasoning, it will do obviously a better work. And now I move, if you don't have any question, I move to the core part of my presentation. I will show you this case, RH versus Sweden. This is a case decided by the European Court of Human Rights in 2014, because I think that this is a very clear case in which we can see that using only traditional epistemology is not enough for a good evaluation of these cases. The case is about the story of a Somali woman, RH. She arrived in Italy, then she moved in Netherlands, and finally she arrived in Sweden, where for the first time after some years in 2011, she made the first request of protection. She then made a lot of requests, 4 at least, but every request was rejected. And at the end, the European Court of Human Rights recognized that her application has two kinds of problems: formal issues and substantial issues. The European Court of Human Rights basically agree in everything with the other courts. So I will report only the justification of the European Court of Human Rights. Among the formal issues, the court talks about the different identities that the woman provided to the authorities, the lies she said about her date of arrival and her marital status. And among the substantial issue, the court talks about the gradual introduction that she made of new elements in every stage of the proceeding after every rejection. In addition, the court highlighted the fact that she wasn't able to justify all the contradictions and lies in her application. The woman gave some explanation of the main criticalities of her application, and you can see a part of them in these slides. The problem is that the court doesn't evaluate in reality these explanations. Why? Because they are referring to something that is not understandable for traditional epistemology. For example, look at the last point about the marital status. She explained her age, that she didn't mention her marriage because she didn't feel married, due to the fact that she was forced to marry her husband. This is something that the traditional epistemology can't understand as a good reason, you know, but the woman had a reason to this failure to explain this point. The thing that I want to explain about the last point here is that with a critical epistemology, we have some tools to understand these type of ungraspable experiences that the refugees can express. So an integrated epistemological approach will be a better tool to understand these stories. Yes, going ahead, I will now focus on the decision of the court, and in particular I will focus on the point 73 of the decision. That is the core part of the decision, because it is the part in which the court decides on the risk. And what I want to show you is that in this crucial part of the decision, the court made a very weak argumentation. So let's see. Here you have the first inference, and we can read. The court considers that there are significant inconsistencies in the applicant's submissions. The claims concerning her personal experiences and the dangers facing her upon return have not been made plausible. Accordingly, there is no basis for finding that she would return to Mogadishu as a lone woman, with the risk that such a situation entails. Because in this case, the problem was to establish if there was a male network protecting the woman. So the evaluation of risk in this case was linked to the evaluation of the presence or not of a male network protecting her. But let's see how this inference can be understood from a logical point of view. We can analyze this inference in the shape of an induction. Here you have with P1, P2, Pn the premises of the induction, and with C1, C2 the conclusions of the court. The induction is a non-deductive inference, and basically the courts are saying to us that proof 1 is inconsistent and has not been made plausible. P2 is inconsistent and has not been made plausible, and so on. Every proof, they are not plausible and are inconsistent. So, conclusion, general conclusion, because the induction starts from singular individual cases and infer a general conclusion. Conclusion 1, there is no reason to think that RH will be a lonely woman in Mogadishu. Conclusion 2, there is no reason to think that RH will be at risk. Look at the climax in these conclusions. Let's move to the second inference. What I want to say about this induction, is that we can think not only to the climax present in the conclusions, but also to the quality of the premises in this inference. The evaluation of inconsistency and plausibility are basically very weak, because the courts used maxims of experience that are not culturally linked. So this is in fact a very weak reasoning. Let's move on. In the discussion part, we can go deeper if you are interested in this. The second inference is this. The court notes that the applicant was informed of the death of her father in 2010 and her mother in 2011, indicating that she has retained contacts in Mogadishu. Moreover, she has family living in the city, including a brother and uncles. She must therefore be considered to have access to both family support and a male protection network. Furthermore, it has not been shown that the applicant would have to resort to living in a camp for refugees. The two important points here are that the brother and uncles that the court cite were part of a terroristic group. So the woman explain that there are not like a real support for error, but the court doesn't consider these elements, considering a lie at this point. The second point, the last one, if you see the last of these lines, the court is saying basically that if you escape from your country and you don't stop in a refugee camp, you are having your family helping you. This is a very strong conclusion and is not justified in any way from the court. So also this is a very problematic inference, but we can analyze logically also this in the shape of an abduction. The abduction is also a non-deductive inference, but differently from the induction, it is used to give explanation. In fact, if you see P1, P2, and P3, these premises are the proof we have. From known facts, we explain unknown facts, the risk at the end in the conclusion. P4 and P5 are, in fact, maxims of experience, so the logical bridge between premises and conclusions. The problem here is that if you look at these maxims, they are very, very problematic. As we have said, P5 is regarding the fact that if you don't stop in a refugee camp when you are escaping from your country, this means that you have help from your family. This is not a good maxim at all, you know. So this is too a very bad inference. But let's see to the conclusions. The conclusions. C1, RH has contacts in Mogadishu. RH has access to the family support. RH has access to the support of a male network. All of these conclusions are inferred by these three, P1, P2, and P3 premises that are not strong at all. So it's very sad that on a very important point, such as the risk, that is the core of the decision, the judge made these very almost like simply inferences that are not justified in any case, because if you go to look the decision, the judge makes references to the COI that are the news that the court have to about the country of origin, but the decision at the end is not justified at all, because this notion came from old reports and so on. Well, let's go on. The comment on this decision, from my point of view, is that, as I said, this is a rational decision, because the court, if you look the decision, the court follows the instruction that the European Union give to judges, and also the courts made a perfectly rational decision. The fact is that the court used a traditional epistemological approach, so it lacks all the subjective part of the proof. The court isn't able to evaluate the embodied condition that we have in this case. Yes. So if you don't have question, I will go on the last part. We have only 2 more slides.
Yeah, we have questions, but we can do it afterwards. You can just
okay.
pop in there. We can come back.
Okay. So truth, the second topic of this presentation. I quote here some sentences from the note on burden and standards of proof provided by UNHCR in 1998, because this is the first document we have about proof and evidence in this asylum field. So it is a very important document. In this document, we see a lot of references to truth. Especially look at the one that say, obviously the applicant has the duty to tell the truth. Is a very strong sentence, you know, the duty to tell the truth. Or let's see the second one, the burden of proof is discharged by the applicant, rendering a truthful account of facts. The applicant has the burden of establishing the veracity of his or her allegation. So truth is important. It's something that European Union and also UNHCR, it seems to evaluate as a good thing to have in these proceedings. But unfortunately, or I don't know, strangely, almost all the academic literature we have on asylum defend a negative opinion of truth. You know, they are defending a Foucaultian notion of truth. So basically, truth is related to power, so it's something that we have to avoid, or we don't have to care about it. And I put here in the slide some name, and at the end you will find the bibliography, so you can like see what they say. These are very interesting authors on this topic. So if you want, you can read them. But in my opinion, I claim something different. The first thing is that we have to disambiguate this topic, because as we said, we in this field we have to prove a risk. So it's very strange to think that we can apply the predicate truth to something that is not happened yet. So it is important to stress the fact that we can't apply the truth to something that is not happened, but we, yes, can apply truth to present facts and past facts. What I claim is that it is misleading to think that any truth can never be established in these cases. And secondly, I claim that it's not good to reject totally the concept of truth from this field, because it is strictly connected with rationality. But what I mean with truth? Well, I defend a Tarskian conception of truth. So I basically have a logical conception of truth, a correspondentistic conception of truth. So G, that is a proposition, is true if and only if G. So if there is something in the word that makes this proposition true. This is my presentation. I thank you so much for your attention, and sorry for my pronunciation. Thank you.
No worries, you were great. Thank you, Elena. Thank you very much. This is really interesting and specific. It's, at least from my point of view, something that quite new, I assume also for the others. Now we have time for discussion. I have a lot of questions, so we can first, I see Anna wants to ask something, and then we can move back and forth. You can also keep the presentation if you want. Maybe it could be easier if we need to refer to some points.
Yeah.
Yeah, go on, Anna.
Thank you, Elena. This is very interesting, truly, especially for me who deals with the philosophy of international law. So basically, I do a lot of also asylum, and not only in.
I can't hear you very. I can't hear you.
No, should I speak louder?
Now it's better.
Okay, so basically, thank you. quite interesting, as Sava said, innovative in a way. I can share some things that I was thinking about while you were talking. So first of all, about the distinction between institutional and dogmatic literature.
Sorry, I can't hear what you said.
The difference between the first distinction between the dogmatic and institutional.
Okay.
So I do agree about the difference you mentioned. I do agree with that. But my main thought was that the purpose of those sources is different. And therefore, it is not surprising that the finds that you had about them. So it's expected to be different. And as you said, they're interconnected, and they should be interconnected, because what we take as a truth, especially in these cases, is actually what you call institutional literature or institutional sources. So if UNHCR comes up with fact-finding a sheet on Pakistan, when we make decisions in asylum cases, we take that as truth, even though it may not be such a case. And I'm very well aware of this, because in Serbia, for instance, the Commission for Asylum or the Office for Asylum, as the bodies that decide on it, give enormous relevance to such fact-finding documents, to such institutional sources. So there we can see an enormous difference of what is truth in a philosophical or realistic world, everyday world sense, and what is truth in law sense, in sense of legal system, right?
I missed the voice for a while, so maybe someone, Sava, you can like repeat for a part, because the last part I missed it. I understand that you said that in Serbia these documents from institutional documents, they are very important, but I don't understand the part on truth. Like
so basically, in legal sense, we take those facts from those sources as truth. That is true.
Like laws authoritative in this sense,
I understand.
Authority means being true, but yeah.
And my second point. My second point is about the burden of proof that you were mentioning in the case law of the court. So as I'm aware, it changed dramatically after 2015. So after the big migration crisis. So most of these points that you made actually changed. So especially in non-reform cases, because nowadays we have something that resembles the burden of proof in discrimination. So the applicant needs to like make it plausible that he or she cannot come back. And once he does it, then the burden shifts on the state to prove.
I know these things, but I didn't mention it because it's another part like of my work. I wanted to stress on truth, because the topic was the truth and there was the document. But yes, it's actually, as you said, I
thought that just to draw your attention to that, if you hadn't
it's very interesting what you said, and actually it gives me the possibility to disambiguate this topic, because it can be if one look only to my presentation, it can be like it can go in error, because yes, something is changing, but the fact is that I start from this point, that is the reality that I saw. There is this huge contraposition between states and institutions that are using this way of work and are like trying to restrict always protection, while there is the academic literature that are like trying to enlarge protection, but they are not talking to each other at all, So for me, the problem is like creating ways in which they can talk, and on truth and the fact of plausibility, etc. I know that, but in reality, there is a huge problem on this point, because European Union gave and UNHCR gave a lot of criteria, a lot of studies, and so on. But at the end, sector operators works only on credibility. That is a very bad criteria for me, because credibility is a subjective criteria, and it gives a huge I don't know to say, a huge burden on the applicant, and to prove sincerity. You are talking about something inside, you are sincere, you have to prove you are sincere. While if this credibility stuff gave a lot of burdens also to the decision maker, because he has to prove the sincerity. That is very, very difficult. So in another presentation and in my book too, I basically defend what you said about plausibility. Plausibility is something better than credibility, and is something that can be a connection between the subjective part and the objective part. So yes, I think that also if the things are changed a bit after 2015, there is a great seek for truth from the side of the judges. Also in Italy, we have a lot of judges that are okay, academic people say to us to enlarge as much as we can the protection, but we have few resources, so we have to do we have to spend money for the one that have more necessity of them. So they want they think about truth as the way to do better decision, to not exploit money, and so in these cases I think something that is still important. Yeah,
thank you so much. Just one more follow-up, if I may. Do you hear me well? On the point of the relativity of the truth, which is apparent to all of us, but when you look at the certain real life cases, it becomes more apparent. For instance, when we dealt with 2016, 2017 with the immigration crisis, at one point we had so many asylum seekers and so many refugees and so many applicants that we as lawyers and that we as legal system had to do something in order to manage the crisis. And at one point, if you remember, some states said, I think even UNHCR, for instance, whoever comes from Syria or whoever comes from Congo immediately becomes capable of receiving refugee status. So he doesn't have to prove the prosecution. It will be what we assume by the fact that he comes from Syria. And of course, it's obvious that it's very far from the real truth. We don't know that. I mean, if he's coming from Syria, that doesn't mean he's being prosecuted, right? But we needed to do something in order to manage the crisis. And that's one interesting indication of how far the legal truth can be from the real truth.
Yes, it's very important. For me, one of the most interesting points are the epistemic injustices, because it is quite an important point in which we can try to do something practical to put in practical this theoretical studies and trying to change something in the practical environment. Yes.
Thank you.
Thanks. Mila also wants something, right?
Thank you, Elena, for this really interesting presentation. I mean, it was really interesting to me, and I realized that I realized that your aim is to trying to connect the theoretical literature and the practice in some way, and I have some proposal for achieving that, maybe indirectly, or I'm interested in hearing your positions on that. So at some point in the presentation, you were mentioning ex ante tools for for achieving truth, if I'm not mistaken. And since in my PhD I'm dealing with access to justice, maybe way for achieving some achieving truth and will be better possibility of applicants to present their cases. So maybe it's not needed to do a lot of theoretic making procedures quite different, or try to decision makers be more aware of theoretical literature on that point, but maybe we just need to invest more money and more resources into lawyers and procedures so applicants can understand what they need to say in their cases in order to achieve decision and get asylum in the countries they want. So maybe indirectly truth can be achieved by having better possibilities to present their cases. I mean, have better access to lawyers and in some sense access to justice.
Yeah, this is
maybe if I can just add, sorry, maybe if I can just add up to what Mila said, because it's very similar, so you wouldn't like respond twice. And first of all, I also want to say it was very interesting for me, very complex. So please be aware if my question is not the smartest one, that's like my fault.
No, please.
In relation to what Mila said, at one point in your presentation, it was written and you said that we can determine the truth of present and past facts, and we shouldn't like abandon the truth as a concept. That is also something Anna covered in her question. But like, maybe I'm repeating, but what I want to ask you, and maybe like just a comment, I feel like that in asylum cases with all their specifics, like the very issue of an existing fact is something we can debate on due to like the emotional and subjective like dimension of this the situation in which the asylum cases are found in. So basically, like, is the level of truth something like Mila addressed, or is there, do you think there's like a higher level of objective truth we can address? Maybe it wasn't clear, but yeah, that's my thinking.
They are very good question. I'm very happy you're helping me a lot, you know, to get better in this work, because now it is published a part in my book, what is in Italian. So I will surely have to write something in English, and I will add for sure your comments because you are helping me a lot. So yeah, I start with Mila and then I move to, can you repeat your name?
Mina,
Yes, we are Mila.
Okay.
Mila and Mina, that wasn't intentional, it just happened.
Okay. So I think this, maybe because I'm a philosopher, I think that the money approach, it can be a very simpler solution, but not always a good solution, because if you give money but you don't like train people to be efficient in something, or to like don't waste this money, you won't have good results, you know. And in this presentation I couldn't like talk too much about that, but there are a lot of studies in which like academics are like explain how like investing in training, like also self-training of decision maker, such as like the fact that a judge, when is like very tired, have to stop like to do his work because it will be biased, and so like this self-consciousness about like the problems is very important, and I think the training is what we lack in this field. And for Nina, but still the money, it will be necessary in any case. So money is always an important thing. For Nina, instead, your question is very intelligent, very smart from my point of view, because you pick a core problem, you know, like it's strange, how to say. We have a lot of things, different things, subjective things related to the person, and objective facts, like if someone has suffered a rape or something like that, etc. And they are both important. So we can say that there is something like a different type of ontology in these two things. So yes, truth is understandable in different ways, in applied to different like ontologies. In my opinion, from a logical point of view, we always talk about G is true if and only if G. But then when we have to explain these referring to different ontologies, we can change, we can like explain better, moving from logic and like trying to do something better. I think I don't have time here to explain this, but in my book I try to provide a pluralistic approach on truth. That is basically this, that okay, from a logical point of view, we can stay in this little definition, but then when we are managing different things, we have to say something more on truth. But I think it's very long and boring to talk about this now. So thank you.
Okay, we have 10 more minutes, I guess. I will try to follow up. I have a lot of doubts, a lot of ambiguity, but it's probably on my side. This is new to me in the sense that I haven't been writing a lot on, in general, legal reasoning. I'm more to the pure like philosophical side of the concept of law and political theories and a bunch of other stuff. And in this sense, also asylum is not my my narrower topic. So Anna and Mila and Mina probably have more insights into this. So forgive me if this is too external, perhaps, if the questions come too wide towards your approach, but maybe they can help clear some things up. So basically, the first thing that came to my mind as you were starting the presentation was the question of the general approach we have to knowledge, especially from the perspective of philosophy of science, and the idea that, as far as I understand it, things have been there is a still relatively clear consensus, I guess, on the idea that we've given up on certainty in knowledge of any sorts, right? That in this case, we're dealing with facts, and if I understood, you're mainly focused on the, let's call the small premise, the factual questions in legal reasoning, right? We're talking just about facts in your presentation, in the whole project, right? Okay, so we're dealing with facts, and in this case, even in natural sciences, we've given up on the idea that certainty is achievable of any sorts. And then I thought what you mentioned later on, which is especially applicable to legal reasoning, but in general, I think to all human reasoning, and that's the idea that we use abduction when we draw conclusions, because abduction is something that I think corresponds best with the conclusions from philosophy of science, in the sense that we can never have inductively enough information, and from that perspective, we anticipate the future by claiming something about the world, but we know it's never enough. It's never going to be certain. So I was firstly wondering whether this aspect is so general, or should be connected somehow to asylum decisions in specific, and whether or not it plays a role in your reasoning about epistemology, because it seems like a general claim. And first of all, in legal reasoning, the main point
sorry, what's the general claim you referring to?
that we have given up on certainty in general, even in philosophy of science, even in natural sciences, therefore. And then the second one is that especially in legal reasoning, we talk about abductive reasoning, and we almost never talk about truth, right? And that's what Anna mentioned, in a way that it's always considered to be relative in this sense. So that's the first thing, is like the general point on uncertainty of any sorts, and how does this fit into your project. And secondly, and this is the main problem I probably had in this sense, is I kind of missed a justification of why, from the epistemic or epistemological, in this sense, perspective, are asylum decisions special. And you've introduced the subjective element in this equation by saying that, as far as I understood you, this is necessary to be accounted for in concretely and specifically the asylum decisions, something of a personal experience expression, right, of the asylum seekers, or I assume. And I was wondering, from the epistemological perspective, and this general idea that we have abductive reasoning for everything, almost, I would say, we don't have enough information ever. Then what's special about asylum cases? I think Mina mentioned this emotional aspect of it, but I think it needs more clarification and justification. Why and in which specific sense are we talking about?
Let me know if I understood this second point. You told about this like subjective part of knowledge that I referring to in the presentation. And but I think I don't understand very well, like, your point on this topic.
Why are, it's basically the question, why are asylum decisions specific compared to other cases in general?
Okay.
When it comes to epistemology, because as I've said, the concept of knowledge, and in this sense, the concept of truth, and even I'm not going into the authoritative decisions on the burden of proof in different systems or whatever. I'm just talking generally.
It's clear. Okay. So first of all, I agree with the epistemic literature. So I know very well that there is uncertainty, that we can't reach certainty. I am like, all of me is anti-Cartesian. So you are like, I think like you. Okay. Well, we have to split our theories of knowledge from our theories of truth. Okay, so we can talk about knowledge in degrees of uncertainties that can be more or less, but we can still talk about truth, that is a semantic part of philosophy, like theories of truth and the analysis of the conception of truth, of the notion of truth, is a semantic issue. There is a huge separation between truth and knowledge, and when we collapse these two notions, we have a verificationistic conception of truth. I am an analytic realist, so as I think the majority of legal philosophers and analytical philosophers, I know still that among epistemologists there are a lot of verificationistas, but in my opinion, it is a conceptual error, because you are collapsing two notions that are not the same thing. You can, for example, like mostly in the physical, empirical things, you can say that you can never have the certainty about something. For example, I don't know, the number of rocks in, I don't know, the mountain X, okay? But still, if someone would be able to count these rocks, someone would have the possibility to say how much they are, or better, I don't know, we can't have access maybe to, I don't know, what is doing someone at this time. Okay, we don't know what he's doing, but if we like let the pen fall, we don't know it, but the truth of that facts remain. Also, in the case we don't know anything about that.
Yeah, like the difference between epistemology and ontology in this sense, probably like something is happening as a fact.
Yeah,
right?
yeah. This is the conception of analytic realism. So two theses. There are facts in the world, entities, okay, and they are not, at least in some cases, depend on us, on what we want, on our mind, etc. And yes, and so yes, I'm an analytic realist, and so I defend like this thesis. Like we can talk about truth, but we can, in the majority of cases, we don't reach the truth. Okay, we don't have the certainty of truth. For the second point, it is very complicated to understand, and I think I will need to like work more on this concept of subjective part of the proof, because in this presentation I let it a bit vague, but basically European Union and UNHCR said like legally that in this field we have these two sides of the proof, the subjective part and the objective part. A lot of studies on asylum talks about this ungraspable experience of people, emotions, experience culturally laden, and so on. So yes, I think it's something that it's a value-laden side of the proof that classical epistemology never like treat before, and I think maybe a tentative to put these approaches together would be useful, but I don't know, maybe it's it's impossible, I don't know.
Yeah, okay, yeah. I mean, that's it's probably this phase in your project. I'm not sure how much you already have and how clear the ideas are, but I also couldn't grasp finally like the solution that you might have in mind for this problem. Like, is it just I mean, Mila mentioned a proposal of this, but do you have currently something that would suffice to say this is the procedural aspect in which we can solve, or just bring together the two parts?
Yeah. I think that there are a lot of like practical things that could be done in this direction. Yes, but I think it is necessary a cultural change, because basically academics and institutions are like they have a lot of prejudice, one towards the other. So if you read the documents, you will see like the ones are like accusing of irrationality the other side, and vice versa. So yes, it's very difficult because it's a political field. So yes, well, we'll try to say something more in the future.
Okay. I guess we can wrap up. We're right on time. Thank you very much, Elena. This was
thank
really
you
great.
to you for your patience and for my bad English.
No. I hope we were really useful, at least to some extent, and we haven't bothered you much. I guess we can finish with this, and I hope to see you in person or meet you in person
yeah,
as
for
we
sure.
get the chance.
Come to Italy.
Yeah, we are actually. We're gonna come to Geneva again, I think in June.
You've been already there?
Oh, we've been twice, yeah, for 2 months.
Okay, fantastic.
Yeah, so we will see you in June, hopefully. We will see you in June, hopefully.
I will be there in June, so.
Yeah, excellent, yeah.
Thank you.
Okay, so we'll stay in touch.
You.
Thank you once again.
Thank
Bye.
you, bye-bye. Thanks, bye-bye.
Savo, moramo da idemo.